Ladies and gentlemen, here we are, as stated, with the rightful, legal, constitutional, and lawful barment of the Trump administration being barred by one of the Southern Texas judges appointed by Donald Trump himself from illegally deporting migrants under the Alien Enemies Act in a southern district of Texas. Let's get into this new breaking reporting by the Associated Press and figure out the reasoning behind this. Whatever it is, we know it's legal, constitutional, lawful, and rightful from judging because the United States, ladies and gentlemen, is currently not in any wars, nor involved in any wars for that matter. The article, ladies and gentlemen, today is titled, like I said, Judge Bars Deportation of Venezuelans from South Texas under 18th century wartime law. And ladies and gentlemen, the article reads, a federal judge on Tuesday barred the Trump administration from deporting any Venezuelans from South Texas under an 18th century wartime law and said President Donald Trump's invocation of it was, quote, unlawful. U.S. District Judge Fernando Rodriguez Jr. is the first judge to rule that the Alien Enemies Act cannot be used against people who the Republican administration claims are gang members invading the United States. Quote, neither the court nor the parties question that the executive branch can direct the detention, unquote, wrote Rodriguez, who was nominated by Trump in 2018, but the judge said, quote, the president's invocation of the AEA, Alien Enemies Act, through the proclamation exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms, unquote. In March, Trump issued a proclamation claiming that Venezuelan gang Trendy Aragua was invading the U.S. He said he had special powers to deport immigrants identified by his administration as gang members without the usual court proceedings. That is where this SOB is wrong. Quote, the court concludes that the president's invocation of the Alien Enemies Act through the proclamation exceeds the scope of the statute and as a result is unlawful, unquote, Rodriguez wrote. The Alien Enemies Act has only been used 3 times before in U.S. history, most recently during World War II, when it was cited to intern Japanese Americans. The proclamation triggered a flurry of litigation as the administration tried to ship migrants it claimed were gang members to a notorious prison in El Salvador, known, ladies and gentlemen, as CCOT. Rodriguez's ruling is significant because it is the first formal permanent injunction against the administration using the Alien Enemies Act and contends the president is misusing the law. Quote, Congress never meant for this law to be used in in this manner, unquote, said Lee Gellerant, the ACLU lawyer who argued the case in response to the ruling. Rodriguez agreed, noting that the provision has only been used during the 2 World Wars and the War of 1812. Trump claimed Trinity Aragua was acting at the behest of the Venezuelan government, but Rodriguez found that the activities the administration accused it of did not amount to an invasion or, quote, predatory incursion, unquote, as the statute requires. Quote, the proclamation makes no reference to and in no manner suggests that a threat exists of an organization, armed group of individuals entering the United States at the direction of Venezuela to conquer the country or assume control over a portion of the nation, unquote, Rodriguez wrote, adding, quote, thus, the proclamation's language cannot be read as describing conduct that falls within the meaning of invasion for purposes of the AEA Alien Enemies Act. If the administration appeals, it would go to the New Orleans-based Fifth Circuit Court of Appeals. That is among the nation's most conservative appeals courts. And it also has ruled against what it saw as overreach on immigration matters by both the Obama and Biden administrations. In those cases, Democratic administrations had sought to make it easier for immigrants, to remain in the U.S. The administration, as it has in other cases challenging its expansive review of presidential power, could turn the appellate courts, to the appellate courts, including the U.S. Supreme Court, in the form of an emergency motion for a stay pending an appeal. However, ladies and gentlemen, on that note, the U.S. Supreme Court has ruled that Donald Trump cannot use the Alien Enemies Act without, ladies and gentlemen, giving them due process. Now, recently, however, they have also ruled that Trump and his administration cannot deport Venezuelan migrants who they allege are Trendy Araga gang members. Continuing with the article. The Supreme Court already has weighed in once on the issue of deportations under the Alien Enemies Act. The justices held that migrants alleged to be gang members must be given, quote, reasonable time, unquote, to contest their removal from the country. The court has not specified the length of time. It's possible that the losing side of the Fifth Circuit Court of Appeals, Fifth Circuit Court, would file an emergency appeal with the justices that also would ask them to shortcut lower court action in favor of a definitive ruling from the nation's highest court, such as decisions likely would be such a decision would likely be months away at least. The Texas case is just one piece of a tangle of litigation sparked by Trump's proclamation. The ACLU, American Civil Liberties Union, initially filed suit in the nation's capital to block deportations. U.S. District Judge James E. Boasberg issued a temporary hold on removals and ordered the Trump administration to turn around the planes that had left with detainees headed to El Salvador, a directive that was apparently ignored. Ladies and gentlemen, it was ignored. There's no apparently. Later, the Supreme Court weighed in. The justices stepped in again late last month with an unusual post-midnight order halting deportations from North Texas, where the ACLU contended the administration was preparing for another round of flights to El Salvador. Ladies and gentlemen, that is going to do it for today's legal breaking and final reporting. If you did enjoy this legal breaking and final reporting for the day, please consider liking, commenting, sharing, and subscribing. Secondly, ladies and gentlemen, if you want to make sure you never miss a brand new legal breaking reporting on the side of politics, please make sure that you hit the the bell icon and click the all notifications options. That way you never miss a brand new legal breaking reporting on the side of politics. Thirdly, please help me reach and achieve the goal of 160 plus subscribers. The reason why, ladies and gentlemen, I am saying 160 plus subscribers plus is because right after we reach and achieve the goal of 160 plus subscribers, we have more subscribers to reach and achieve right after we reach and achieve the goal of 160 subscribers. Next, ladies and gentlemen, fourthly, please, if you want to make sure you never miss a brand new legal breaking reporting on the side of politics, please follow me on my social medias as well as the bell icon. That way you never miss a brand new legal breaking reporting. There, on my social medias, I will be posting when I have uploaded brand new legal breaking analysis reporting videos on the side of politics. Lastly, ladies and gentlemen, please stay positive, stay safe, and know that justice will prevail on the correct side of the law eventually, despite Donald Trump and his illegal, unconstitutional, unlawful, wrongful administration and regimes, executive orders, actions, and behaviors. And until my next reporting, as stated, please stay safe and please stay positive. I will catch you guys in the next legal breaking reporting.